If you are comfortable writing it in a piece of paper, write it and send a picture to me. That is fine. Pressure it's still pending. Okay. Is this the only difference that you will mention? I'm asking with respect to how you will answer these questions. You know why I'm doing this entire drill? Because I'd asked you all to write answers and send it to me. Okay. Although I told it's voluntary, I didn't find anyone send the answers. Done or you need more time? Okay. So out of the entire batch, I had only 3 or 4 people who at least bothered to reply. But yeah, just one word or 2 words answer. Guys, let me tell you, we are already at the end of September. Okay, October and November are the only 2 months you have. And if I say the level of commitment, interest, and preparation is really less. Okay, if this will continue, it gets very difficult for all of you to manage in the last minute. I'm telling you not just because to scare you all, I'm telling you because I have experienced this. Okay. Please, please, please start studying. Don't give vague answers like this. Okay. And while you are studying, ensure that your approach is proper. That is, your approach is something that you're writing your exam. That should be your approach. Even if I ask you a simple question, what's the point of revision if you're not prepared at all? Correct. So I don't want this sort of response in the class. This is the last time. Next time, whatever we discuss in the class, it should be in your fingertips. It has to be. You don't have a choice. Okay. So until what we have done in civil procedure code, I want you all to be pakka with it. Okay. We will move on now, but next class, I'm not going to spare you all if I'm getting really vague answers or, answers just for the sake of it. Okay. So let us begin with the next topic called appeals, right? What do you know about appeals? What do you mean by appeal? Give the most simple definition you know, but at least tell me what do you know about appeal? Come on, quick.
Challenging a decision.
Sorry? I couldn't hear you, Siddharth.
I'm challenging a decision.
Challenging the decision, okay. Anybody else? On what grounds will you challenge a decision?
If we think a decision which is made should be in my favor because they're based on the evidential proof. So
Right.
we go
Okay.
and we
See, this is
challenge the decision.
correct. So this is a very basic understanding of what is this one. what do I say, of what is an appeal. Okay. Generally, what happens when I have to go for an appeal, it is for the question of law. Okay. See, the simplest definition for us to understand is go to the higher court. That's what we studied when we did civil procedure. I mean, when we did Information Technology Act or RTI. Okay. But now we have to understand a better definition. And to understand a better definition, we need to know what is this term called appeal. Okay. Now, appeal is challenging the decision of the lower court and moving to a higher court. Okay. For the question of law. Now, say you know the section really well. Okay. You know that case, the court has not considered a particular section. Only then you can challenge the decision of the court. Okay. Not everyone get the right to appeal just like that. Okay. So now what we understand is the higher level of definition, where it says that when there is a question of law, only then you get to go to the court. Okay. Now you understood the definition of appeals?
Yes, ma'am.
Okay. Now, one second, guys. Just 1 second. Let me share my screen.
So, ma'am, the basic understanding is basically when a lower court passes a statement or a decision, if we are not satisfied, we go for the other legal options to the higher level to oppose that decision.
Correct. Okay. Now comes the complicated part. Now, if the court has passed any decision, considering all the points of law, okay, the section is not violated, nothing is wrong. Okay. If the court has passed a right decision, do you think it is fair for you to go and question the decision of the court in spite of it being a fair decision?
No.
Second thing, okay, if the decision that the court has taken, okay, has been with your consent, is it possible for you to challenge the decision of the court? No, right?
No.
Now comes the complicated part of an appeal. Okay, not every appeal will be satisfiable. Okay, appeal which are a question of law. Okay, which have the question of law, and appeal for which you have also agreed, right? Such appeals obviously cannot stand good. Like, say court has taken your consent and passed an order, right? For that you can't go and appeal. Okay, so appeal lies when there is when there is a question of law which is not resolved. Second is when it has been passed without your consent, like you know that the court has not considered certain facts, only then you can go and appeal. Okay. Now, talking about appeal, we have 4 different types of appeal. Okay. Appeal from an original decree, second appeal, appeal from orders, and appeal to the Supreme Court. Okay. Original decree is when you are, you file an appeal with the superior court against the subordinate court. Okay. That is called as original appeal or appeal from an original decree. The second appeal is when you file an appeal at the next level, that is at the high court level. Okay, that is called as second appeal, right? The next appeal comes when you have the right to directly go on an appealable order. Okay, I'll explain all of these things. What is an appealable order? Okay, there are certain orders, okay, which by itself gives you right for appeal on grounds or defect or irregularity of certain law. Okay, that is certain appeal under section 35A, under section 95. Okay, these sections we'll study at the last while I explain you the sections relating to order which we had left. Okay, so certain orders are appealable orders. Order comes with the right of appeal. Okay, so in such case, or certain appeal comes with a condition that it will be appealable at Supreme Court. Okay, so for such reasons we have the right of appealing, that is appeal against original decree, second appeal, appealable orders, and appeal to the Supreme Court. Am I clear?
Yes, ma'am.
Okay. Guys, just if you can just give me a minute, just 1 second.
at what time did the class start, Sidharth?
4:37.
4:37, ma'am.
Oh, okay, okay, fine. It's a civil procedure code, right?
Yeah, the same chapter.
Okay. Everyone in the group has finished the pre-test and paid for the exam, is it?
I think so, Vani. Most of us have completed. Because if anybody has left out, the only provision they have is the late payment fee, but there is no possibility of completing, because even if you pay also, you won't be able to go for December.
Is it so?
Yeah, because the deadline was like, if you won't complete 3 days, you are not eligible for fees. Even if you do
That's
late
right, that's
fees,
right. But
it won't work.
no, but the thing is, I think they've extended the time for clearing the pre-test.
They have only extended the time frame only for the fee payment. If you see the last Thursday's mail, what we received a PDF. It only
Okay.
mentions about the examination from 29th of September
Okay.
from 26th of September to 10th of October with late payment fee, which means you have to pay 1450.
I received a mail saying that the pre-test clearing the pre-test also it's extended because there was some issue within the website and students were finding it difficult to log in, something like that.
That was only for one day where TCS servers went down. One of the main server which was releasing the test paper went down for some technical reason.
Oh, okay.
It was only for it was not 1 hour, it was some few hours. The test server went down for some reason, it was not connecting. There was having some network issues in the TCS data center.
Okay. So Malatha madam, you also paid for the exam, is it? Finished?
Yes, ma'am.
Yeah. Okay, fine. You're also working, right?
Not yet, ma'am. Actually, before I was working,
You've taken
but
a break.
now I'm not working.
Okay. I'm finding very difficult with tax laws.
Vani, you can log into e-learning portal, okay, and then find out the courses enrolled option is there on the top right. You click on this, find executive tax law video lectures.
Okay.
Then go through, because what they have done, direct taxes, indirect taxes, they have clubbed up and all the important one. So watch that is giving 4 or 5 parts it will be. 25, 24, 26 minutes like that. So watch that, it might help you out. Because I went through 2 of the videos, it's clear because they talk about the provisions and the sections and everything, and also they solve few questions also for each section.
Fine. Thank you. Yeah, ma'am. Continue, ma'am.
Okay. Done. Nice to see some people at least interact in the class. I think some 7 to 8 online batches I've seen people didn't even know who each other are. So that way, I'm happy you guys are at least interacting with each other. Okay. So let us start. Sorry, I'm so sorry. The problem was with 1 second. Yeah, there was some KYC verification that I got an OTP, so I had to verify it. Otherwise, otherwise the whole work would have gone for a toss. So that's why I had to do it. Sorry for that break. Right. So now moving on to talking about appeals, right? Now, the biggest question maybe, first one, appeal from original decree, it's very simple. Okay, first time when there is a question of law, you are not satisfied with the question of the law, you appeal. Okay, that is original decree. The second appeal lies with to the High Court. Okay, from any subordinate court, if the High Court is satisfied that you have to file a case, as in High Court is liable for filing such cases. Okay, that is the next level. Okay. Now the confusing part comes the appealable orders. Okay, generally if there is if there is any defect or irregularity in the law, okay, in such case what the court does is it passes an appealable order. You can further go appeal under section 35A, 91, 92, 95, or under Order 43. We'll understand each one of them separately. Okay. Next comes appeal to Supreme Court, where it has been specifically mentioned that you have the right to appeal to Supreme Court. Okay. Only such cases directly after the first appeal, then the second appeal, you can further directly appeal with the Supreme Court. Am I clear? The next comes the three different concepts called reference, review, and revision. Okay. Now, what is this reference, review, and revision? First thing is reference to the High Court. Now, any subordinate court, okay, if they have some issues in passing a particular judgment, okay, that is in case they need to refer, or that's what we all also do, right? I mean, in case we don't understand a particular point, we definitely refer to our seniors. Yes or no? Same thing even the court does. So what the court does is they refer the court to the High Court. Okay. So High Court may pass an order as it thinks fit as per the reference passed by a subordinate court. Okay. So before passing judgment, they refer to the High Court, just like how we refer to our seniors whenever we need help. Okay. Similar way, the courts also refer to the higher court. Okay. The next concept comes about review. Now, what is a review? Generally, when do we use review? Whatever decision has been passed, okay, you want to, ask them to look back at the decision. This is not appeal, okay. Here, you are asking the court to review their judgment on the grounds that certain evidences provided was not sufficient, okay, or there was some mistake or error in the face of any record, or for any sufficient reason, right? Now, when I'm talking about appeal, okay, in appeal, we don't review the appeal, okay, we directly challenge the decision for the question of the law, okay. Now, if there is some defect in the evidence, if there is some defect in the document, that is not checked in, in an appeal. But in a review, if there is some new evidence that is found, or if there was something that was not considered, then you file a review with the court for reviewing their own judgment, telling that some matters were not considered, or there was some mistake or error in the document, or for any other sufficient reason.
Like in a cricket review.
Sorry?
Cricket review. They ask for
Correct. 100% like a cricket review only. Okay. So, only thing is in cricket, it is only the umpire's decision. But here the question is any failure of any documents that is submitted or some error in the documents submitted. Clear? Now, the next one is revision. Okay. Now, revision is ordered by the High Court. Okay. Where any subordinate court has taken up a case beyond their jurisdiction. That is, they were not ideally supposed to take up that case, but they have taken, or they have not exercised their jurisdiction, okay, or they have acted in an illegal manner. Any subordinate court or any court has acted in an illegal manner, then the High Court, okay, will send a notice for revision, okay, and High Court will take up such case where the subordinate court have failed to do their duty. Okay. Now, it is not mandatory for High Court to revise or reverse their decision. Okay. It might stick on to the same decision, or it might have to change the decision. But revision is taken up whenever the court has not done its duty properly. It's more like school principal taking the responsibility of a teacher who has not done the work properly. Is this clear? So there are four different concepts. Okay. Appeal is when there is a question of law. Whenever you talk about appeal, don't miss to write question of law, because otherwise it gives a very different meaning. Okay. When there is a question of law, okay, and when the decision is not by the consent of both the parties, one of the party has the right to appeal in a higher court. Okay. In appeal, there are four different types: against the original decree, second appeal, that is with the High Court, specific appealable orders, and appeal with the Supreme Court. Next comes reference. Reference is when any subordinate court takes reference to High Court's decision. Okay. Review is when an applicant files an application for review to the court which has passed the judgment to review their decision because of discovery of some new evidence, important evidence, or some mistake or in the documents produced or in the records, or any sufficient grounds. Okay. Revision is when High Court takes a revision on the decision passed by a subordinate court if they have gone beyond their responsibility. That is, if they have not exercised their jurisdiction properly, or they have failed to exercise the actual jurisdiction, or they have done anything in an illegal manner. Am I clear?
Ma'am, a doubt.
Simple. Yeah.
In the review, it's like the subordinate court gives the decisions to the High Court to judge, is it?
Sorry? In review?
In review,
or
is it
revision?
like the subordinate review?
No. See, in review, it is, I am a plaintiff. Okay. There is a respondent. Now this one order has been passed against me, the defendant won. Okay. But after the case is over, that is after the judgment is passed, I have realized that there was an important evidence that I have not submitted to the court. Okay. Or some document which was submitted is a forged document. Right. Now, instead of again filing a new case for it, I might file an application with the court telling that review your judgment. I have got new proofs. I've got new evidences. I've got to know that the proof that was submitted to you was a wrong document. So you please review your order. Okay. The applicant, either the plaintiff or the defendant, will file for review.
So no High Court in this picture, right? In this.
No. For review, there is nothing of that sort.
Okay, understood.
Clear? Okay.
Yes, ma'am.
Right. Next, we move on to a very important aspect. That is, all this while we were only thinking about, an individual filing a suit, an individual filing a suit against another person and all of it. We never thought of how it is going to be in a corporation, or rather a body corporate, right? So basically what happens, most of the civil cases have body corporates as parties. Right. If that is the case, what happens in any suit which is, filed by a corporation or against a corporation, the pleading may be signed and verified by a person on behalf of the corporation. Okay. It can be a director. It can be any principal officer. It can be a secretary. This is where we come into picture as company secretaries. If we are on the board of any company and the company does any illegal activity, or the company wants to file a suit, we as company secretaries have the right to sign such documents as authorized signatory. Yes. So feel proud about yourself also if when you become a company secretary, or feel that risk also that if your company does anything wrong, you will also be liable. Am I clear? So usually when it is a company or when it is a corporate, it is either the secretary, the director, or any principal officer. Now, where do we serve summons? Where do we send out notices? It is sent to the registered office of the body corporate. Okay. Now, whenever there is personal attendance required, then the secretary or director or any principal officer will have to represent the company for any questions asked relating to the suit. Clear? I had one of my faculty who would always say, whenever anything related to company secretaries that we would read in our book, say company law or any subject, wherever the word company secretary used to come, he would make us write myself. Okay, so that whenever you read it, you understand what is your role and responsibility. Right. The next one is suits by or against minors. Okay. Now, who are minors? People who have not attained the age of 18 years. Right. Now, the question is, people who have not attained the age of 18 years, can they go to the court as plaintiff? Can they go to the court as defendant? Okay. Now, for every person who is not completed 18 years, and for a person who is the guardian of any property under the Court of Wards, the age of majority is 21 years. So, generally, minor is 18 years. For a person who has a property, okay, who has been appointed a guardian for such property, then the age is 21 years. Okay. Now, every suit that a minor files, okay, he will have with him a person called next friend of the minor, who is a major. Okay, so more or less like a guardian, but next friend is called only for that specific suit. Okay, that next friend should be of a sound mind and he should be a major. Okay, so in the interest of such person, the minor can file a suit after he is appointed another person called the next friend. Okay, now if the suit is instituted without a next friend, that is without a major person, then the defendant might apply for the plaint to be taken off the file. That is, since a minor is filing, okay, and he doesn't have a next friend also, the defendant can tell that take off this case from the file. When the minor attains majority, we will look at it. Okay, next, if the defendant is a minor, that is, till now we spoke about plaintiff being minor, 2 cases. Okay, if he has a next friend, then he can file a suit. If he has not appointed a next friend, then the defendant has the right to take off such cases. Okay, next comes if a defendant is a minor. Okay, he shall appoint a proper guardian for such minor, right? So next friend is different, guardian is different. Guardian will be guardian for life till he attains majority. Next friend is only for that particular suit. Okay, so if the minor is the defendant, then he has to appoint a guardian. Okay, and when the minor attains majority, wherever the cases have not been, instituted or it has not been tried, then when the minor attains majority, he can reapply for the same case. The application should be reapplied so that once the minor has attained majority, either as a plaintiff or defendant, the suit can go on after he attains majority. Am I clear? Yes, no, maybe.
Yes, ma'am.
Yes, ma'am.
Moving on to the next concept. So these are all very small concepts that we are discussing. Okay. The next concept is about summary procedure. Okay. Now, basically, in the most simplest terms, summary procedures means all these small bachu kind of cases. Okay. So what happens in such cases? You need not want to have like a proper hearing and all of it. Okay, these cases are like I gave him money, he didn't return back to me. Now for like that, you might find lakhs of cases in India, right? It is a very small thing. As long as you prove that you have given money to him, we are done, right? Now say I have given money, he has not given it back to me. Okay, if I have a proof that he has not given it back and I have given him legally, the case is over. The court has to order him to give back my money. Yes or no? You don't need another person to come and tell that yes, no, maybe and all, correct? So these are called as summary procedures. Summary procedures are small cases where the, prayer is only for recovery of money. Okay. Ultimately, you're filing this case only for recovery of your money. That is for some, bill of exchange or some small loans that you have given or some promissory note. Right, it is only to recover the debt. In such cases, in such scenarios, the suit that is filed is called as a summary procedure. Okay, what happens in a summary procedure? Sorry,
like these cases are related only to money matters or other small petty cases?
It is only related to money matters, especially recovery of debt.
Okay, and is there some amount, like there's a limit?
No. There's no limit as such prescribed. But whenever it comes to recovery of debt, okay, like you promised someone to pay and you have not paid, only such cases will come under summary procedure. Okay.
And it can run into crores also?
Sorry?
It can run into crores also?
Yeah, see, amount is not the criteria here. Here the transaction is the criteria. Okay, as long as it is proven that you have lent money to another person, you obviously deserve to get back that money. This is not in return of some services. This is not for some favor. This is purely lending and borrowing. Okay, so when you borrow, you have to recover your debt. He has not paid back to you, so you go to a summary procedure. You file a summary procedure. Okay. Here, what you're avoiding is that 101 steps of sending summons, and then he's sending his defense statement. Then again, you file something. Instead of doing all that thing, when you know that you have to recover money from him, you're ultimately ending up taking money from him. Okay. The rules that will apply to this is similar to High Court, City Civil Court, or any small court itself. Okay. The rules for all of it will remain the same. It is only for recovery or a fixed money that is in the nature of debt. Okay. No penalty and all involved. Here, basically, you don't want to penalize that person. Ultimately, you want your money back, whether with interest or not. Okay. So such cases are called summary procedures. Now, when I say summary procedure, it doesn't mean that there won't be hearing at all. Okay. It might be there, but summary procedures are dispersed faster than in any other cases. Okay.
Okay.
Clear?
Yeah.
Okay. There is no other relief you are claiming other than your money. Okay. Then it is summary procedure.
Okay.
Okay.
Yeah.
We'll move on to another concept called leave to defend. Okay. Now, what do you mean by defend? What is the basic understanding of defend?
Whatever I have made,
protect
prove that I am
oneself.
right.
Wait, one by one.
To protect oneself.
Yeah.
One of you tell, no?
Kushal, go ahead.
To protect oneself. Yes. To protect oneself from any harm.
Okay. Yeah, next.
To make sure that whatever I am claiming, whatever I am saying is true. From all
Correct. So when do you defend? When you feel that someone has, filed any allegation against you, and you defend when you say that no, that is wrong. Correct? That is when you defend. Now, suppose the plaintiff files
The defending
some
the
claim.
person defending himself means that he has not done anything like that.
Correct. So you want to prove that you are right. Correct. Now, if the plaintiff is filing some allegations against you, you are aware of it. Okay. And you have agreed that what he has told is correct. Do you need to defend yourself? Did you get my question? Now, if the plaintiff has told something about you, which you are agreeing, yes, this is true. Do you need to defend yourself?
No.
No, right?
No.
That very concept is called as leave to defend. Okay. Now, court might grant leave to defend. Okay, to the defendant if he himself has admitted, okay, that whatever the plaintiff has claimed is true. Correct. If he himself has told that whatever, or he is a party in the statement that the plaintiff has filed. Okay. That is, if any part of the amount that is claimed by the plaintiff is admitted by the defendant, like say plaintiff says that he owes, the defendant has to pay 1 lakh to the plaintiff, and the defendant agrees that I owe 1 lakh, then that is called as leave to defend. Next, he need not be served all those 100 other notices, documents to defend himself. He is granted leave to defend, and the case will move on thereafter. Is that clear? That is nothing but leave to defend.
Ma'am, one moment.
Any doubts?
One moment. Now, if the defendant is agreeing to what the plaintiff is saying, why do they have to go to the court, ma'am?
See, you are going to the court for various other reasons, right? He is agreeing to one of the allegation, or he is agreeing to some portion of what he's telling, right? Now, I might go to a court, okay, for court's order to understand what has to be done. Now, don't relate this to summary procedure, okay? In summary procedure, it was only related to money, okay? Now, me and my brother go to the court because we want court to partition our property, right? Now, in this case, I am filing a suit against my brother, right? Because I feel that he shouldn't get so much, I shouldn't get so much, and all those stories, right? In that he agrees that this portion is mine. Okay, when he agrees, I want further remedy from the court that the property should be equally distributed or whatsoever it is, right? So if I'm agreeing to certain things that the plaintiff has filed, that doesn't mean case gets over there, right? The suit might have many other prayers for which we need court intervention.
Okay.
See, we don't go to the court only when there is a violation, right? We go to the court for getting legal remedy as well. Are you getting my point?
Yeah.
Huh. So, see, even when it comes to the money, okay, money part. Now, I am telling that that person has borrowed 1 lakh from me, okay? He has not given his money back, right? Even the defendant in any of his statement, makes a point to agree that yes, she had given me 1 lakh rupees, right? That doesn't close the case. I am claiming for damages also from him. I am claiming for interest also from him. I am going to the court to tell that, that 1 year that he delayed giving back my money, I have gone through losses. I need additional money from him. Those things and all court only will decide, right? Considering the situation. He has agreed that he owes me 1 lakh. So he need not file a defense statement. That's all. Okay. But the case might still go on. Clear?
Yeah. Clear.
Understood? Didn't understand?
Understood.
Understood.
Okay. Now, next comes summary judgment. Okay. Now, summary judgment is not related to summary procedure. These are two different things. Okay. Now, summary judgment, okay, may be given, right, at the cases where there is no succeeding claim or defense by the plaintiff or defendant. Okay, that is before passing the final judgment, a summary judgment is given where there is no further claim by either defendant or plaintiff. Okay, or there is one specific reason or there is a compelling reason that the claim should not be disposed of before oral evidences. In such case, a summary judgment is passed. Am I clear? So summary judgment and summary procedure are two different things. Okay. In summary procedure, it is about small cases, right? In summary judgment, basically summary judgment, is applicable to commercial disputes. Okay. Now court will grant this summary judgment against the defendant where the court feels that the defendant has no real prospects. That is, the defendant doesn't have any prospect or successful defense against him. Okay. And then there is no reason why the claim should not be disposed of. In such cases, what the court does, it passes off a summary judgment. Okay. So what all are the points we should understand? Summary judgment are in commercial disputes. Okay. Court will grant a summary judgment against the defendant if the court feels that he doesn't have anything against his defense or there is no reason why the claim should not be disposed of. That is, whatever claim is there, it has to stand. It cannot be disposed of. For these two reasons, the court will pass a summary judgment.
Ma'am, commercial disputes means what, ma'am? Commercial disputes. Actually.
Sorry?
Commercial disputes. Means what actually it is? Commercial disputes,
wait.
actually.
Commercial dispute. What is a commercial dispute? Anyone who knows what is a commercial dispute? Heard of commercial dispute? Usually, basically, commercial dispute is when there is no litigation as such. Okay, commercial dispute comes when there is any monetary value involved. Okay, so in such cases, we file a commercial dispute. I mean, it is called as a commercial dispute. Okay, it is basically only because of any business transactions or any such transactions related to money, but not any specific violation of any act or any provision. Okay, so whenever there is some transaction in money, or I can say, see, earlier this commercial dispute came from the mercantile law. Okay, the terminology has been, driven from mercantile law, where they would talk about import, export, and such other disputes. But now, in a broader perspective, it deals with anything that has to do with money and not violation of the act, but violation of any transaction. Am I clear? Yes, no, maybe.
Yes, ma'am.
Yes, ma'am.
Ma'am, can you brief summary judgment once again, ma'am?
Yeah, so basically, summary judgment is applicable for all commercial transactions. Okay. Now, what happens in a summary judgment is the court, if it feels that the defendant, okay, has no stand in this particular case, or there is no justifiable grounds on which you consider the defendant's fact, there is no defense, okay, or there is no reason for which the case should not be disposed of, as in there's no reason for holding up the case, better to dispose of the claim that is filed by the plaintiff. In such case, what the court passes is a summary judgment.
Okay.
Okay.
Is it like similar to what is it? Not adjoined or something was there, right? Similar, is it?
That is different. That is misjoinder of parties. Like some parties have nothing to do with the case. Okay, that is misjoinder of parties. Here, basically, the court decides that there is no grounds for the defendant at all. His defense statement is meaningless, rather, or there is no strong grounds for which he has defended himself, telling that the plaintiff's claims are wrong. So when you know that his defense is not strong, the court will pass a summary judgment telling that your defense is not strong, boss. So the case will be dismissed considering what claims the plaintiff has filed.
Okay. And after the summary judgment, there will be a final judgment, is it?
Yeah, I mean, final judgment is a statement that is passed. Final judgment will be there in any case for that matter. This is called a summary judgment. So what happens in a summary judgment in practical scenario is the entire rights, duties and all those things that are mentioned in any of the orders, okay, is usually not given because the court feels it's a summary judgment and they need not consider the point that the defendant has made because defendant has made baseless defense for the allegation.
Yes, ma'am. Okay, understood.
Okay, all right. Now moving on to the last part of this chapter that talks about section 151. Okay, now section 151 says if there are certain things that is not covered under this code, okay, the court can take up such cases to meet the ends of justice or prevent the abuse of the process of the court. That is, certain things are definitely not there in the code, but if there is any situation where justice has to be served, okay, the civil procedure code, or rather the civil courts have the power to take up such cases, okay, ultimately to serve the end of justice. Okay, and when I talk about section 151, okay, which says that you can take up cases for justice even if it is not mentioned in the code, that is obviously the civil procedure code might not include everything that is there. This is more of an exclusive clause. Okay, here they say that court can take up any cases for which justice is required. Okay, but that does not mean they go against the code. Okay, this is a provision only for scenarios which is not mentioned in CPC. Okay, but for which there are provisions mentioned in CPC, the court has to follow what civil procedure code talks about. Okay, for what is not given in this, the court, if it feels that there has to be justice for an end to this case, then they can take up such suits. So it is more of an exclusive power given to civil procedure code. Clear? This much if you understand about section 151, it is enough. So you need to understand that the court can take up cases for the purpose of justice if it is not specifically mentioned in the civil procedure code. Clear?
Yes, ma'am.
Yes, ma'am.
Okay. So this brings an end to the very long chapter CPC that we studied. I understand this is relatively dry compared to the other chapters, but I hope you have understood the concept because this is a very, very important chapter. Okay. With this, we will take a break for 5 minutes. Okay. And then start a new chapter. Till such time, if you have any doubts, please just go through what we have done today. We'll revise it once again. What is pending on me is about those appealable orders and those sections that we had to discuss. We'll do that after the break and then start a new chapter. Okay? Okay, you need not leave the room. You might just mute yourself or turn off your video or take a break and get back fresh. appeal if it has been specifically mentioned. Other than that, which comes under those 4 categories. And those 4 categories are nothing but what we just studied, appealable orders. Okay, so basically the intent of appealable orders is when court has considered false facts and has passed an order, it is by in itself an appealable order. Am I clear?
Yes, ma'am.
Yes, ma'am.
Okay, with this we finish the civil procedure code. Okay, I will tell you as a jurisprudence faculty itself, the next time when you're reading this chapter, it might get confusing for certain people. It might be very simple for certain people. Okay, don't get tensed that it is confusing. All other chapters are still okay, but please revise CPC. Otherwise, this is more like one foundation chapter. Okay, if you're not very clear with this chapter, many other things become confusing for you. Clear? So somehow ensure that you study CPC before the next class. Okay, with this we'll move on to the next chapter. Is this Indian Penal Code or Criminal Procedure Code? Okay, now I want you guys to tell me which chapter you want, Indian Penal Code or Criminal Procedure Code. Choice is yours.
I want criminal procedure code.
We are told CRPC only, right?
Okay, then let's do CRPC and then come back to Indian Penal Code. Okay. Now, the first thing we will have to understand is the Code of Criminal Procedure. Okay, it was initially passed in 1898. Okay, further it was repealed and Code of 1973 was passed. Okay, this was passed in the year 1973. It got the parliamentary assent and it was applicable or made effective from 1st April 1974. Okay, now it consolidated every other law relating to criminal procedures. Okay, now we as company secretaries, we don't have much scope to do with criminal procedure code. We don't fight criminal cases as such, but to ensure that we safeguard our company, our directors, or we safeguard our professionals against all these criminal offenses, it is very important for us to know about criminal procedure code. Okay, now when we talk about criminal procedure code, CRPC and Indian Penal Code are to be read hand in hand. That is, we have to read CRPC and Indian Penal Code together. In criminal procedure code, we have been given procedures of how a criminal case should be filed, what are the procedure, which court do we go to. There we understood in civil procedure code, we understood about what are the levels of court and all. Similarly, in criminal procedure code also, we understand what are the different type of courts, what is the procedure, what is an FIR, how you have to file an arrest, how you will get a warrant and all of it. Okay. But why I say criminal procedure code has to be read with Indian Penal Code is for all the offenses. Okay. The penalties are given in Indian Penal Code. The procedures are given in criminal procedure code. Like say there is section 420 in Indian Penal Code. What is 420? It's a very good slang for all of us to use this terminology called 420. Okay, but 420
the fraud actually, the forgery.
Exactly. So in Indian Penal Code, it talks about fraud related activities. Okay, so if there is a fraud, okay, what is the procedure, right? Who will be arrested? What has to be done is given in criminal procedure code. What is the penalty for that fraud is given in Indian Penal Code. Okay, so understanding certain definition, right? What is an offense first? An offense is where the legislature says that it is punishable. Any act which is punishable is nothing but an offense. Okay, so any act which is punishable is an offense. That is, when I say any act, it means doing something or not doing something which is punishable under law. Okay, that is nothing but an offense. Now comes a very important definition called mens rea. Okay, now this is one universal definition that the minute you say mens rea, everyone will know something or the other about mens rea. Okay, basically mens rea means a guilty mind. Guilty mind, when I say, it's not that a person admitting his mistakes. That is not a guilty mind. Mens rea means a intention to do something wrong. Okay. See, you will do a criminal offense only when you have that intention to do an offense. Agree? I mean, randomly, nobody will go and murder another person without any intention, right? So, for anything to be punishable under the Criminal Procedure Code or the Indian Penal Code, there should be an element called mens rea. Mens rea makes any offense punishable with an intention to do something wrong, right? There must be a fraudulent mind, or there must be a criminal mind to do something wrong. Agree or not? If I have to rob something from someone's house, if I have to kill someone, any criminal act, okay, it has to have an criminal mind to do it, and that is called as mens rea. Okay, so for every criminal offense, mens rea is an essential ingredient. Okay, just to have a motive to kill is not enough. Yes.
There are these words, this what they've given, mens rea and other things which we studied earlier also. These are derived from which words? Like,
these are all from the legal, Latin words, the legal words. Like, say, when you talk about equity shares, you mentioned that equity shares, rank pari passu, res judicata, these are all legal terminologies. Okay, so mens rea basically means the act of, or rather an act which has a guilty mind. Clear?
So these words are, they use it in the thing?
Yes, very much. Mens rea is like widely used, okay, because logically also it's an essential ingredient. Some terminologies are still legal terminologies itself, right? Okay. Next, talking about bailable offense and non-bailable offense. Okay, what is a bail?
Like by paying something, you get that.
Yeah, I'm sorry, Kushal, I intervened. You can tell me, what is bail?
Like when when you are in a jail or something, you pay the fine and you what is it? Okay. You pay back the fine something.
Okay. Anybody else?
You're temporarily taking out of the jail by paying some amount as security.
Okay. Close by. See, basically, bail is not
the cognizable case.
Sorry?
The offense means which is the cognizable case, no, actually. Bailable offense means.
Correct. That is next. I'm asking generally. I have not even explained about cognizable and non-cognizable. Okay, I'm only asking you, what do you know about bail? We would have seen in movies and all. See, this chapter is very easy for me. Yes.
No. Okay. The granting or relieving from the person from the jail on the behalf of that personal.
Okay.
And only to few offenses. Not all offenses can't be given bail. Only few offenses which is described, and those they can be out for some time.
Certain period of time.
Basically, I'll tell you the simplest thing. Okay. Usually we don't use the word jail. Okay. What we say, he is under legal custody. That is the legal, the police people or the legal people he is under their custody. The criminal is under their custody. Okay. So bail is release from the legal custody to any private custody. Okay, now when I'm applying for bail, there is another person who is giving surety that he will ensure that that person is not moving out of the country or not doing any further offense. Okay, bail means moving from the legal custody to a private custody. Okay, like from government to private. Okay, it's similar to that. So you are still under the custody itself, but not under the legal custody or in a jail. You are under the private custody of another person Who has signed surety for you? Who is telling that I will pay this much amount as surety and I will sign on his behalf that he will be under my custody? That is actually the definition of bail. Okay. Now there are certain offenses which are bailable. That is, for certain offenses you can avail this bail service. That is, you need not be in the legal custody. You can be in a private person's custody. Okay. There are certain offenses which are non-bailable, simple. Okay, which are all not mentioned as bailable are all non-bailable offense. Now, to read Criminal Procedure Code, it is very easy. Okay, you have first schedule of Criminal Procedure Code. Let me just type it out on Google. First schedule of CRPC. One second, let me just share my screen. Yeah, can you see my screen now? So this is actually the first schedule of the Criminal Procedure Code. Okay. Now for all the offenses under the Indian Penal Code, here the name of the offense is given. Okay. Whether it is bailable or non-bailable is given. Whether it is cognizable or non-cognizable is given. Okay. So that is what is given in the first schedule. So for all the offenses which are considered bailable under the first schedule, it is called as bailable offense. Where it is not mentioned, it is non-bailable offense. Clear? Next, we come to the category of cognizable offense and non-cognizable offense. Okay. Now, cognizable offense means offense and offense for which the police officer, in accordance with the first schedule, or arrest a person without a warrant. That is, cognizable offense are those offenses where a police officer can arrest without a warrant. Okay. Whereas non-cognizable offenses are those where he has to arrest with a warrant. He has no authority to arrest without a warrant. For cognizable, you can arrest without an arrest warrant. For non-cognizable, you cannot arrest without a arrest warrant. Now again, to understand which all are cognizable and non-cognizable, we again refer to the first schedule. In first schedule, one exhaustive list of offenses are given and they have mentioned whether it is cognizable or non-cognizable. Okay. We cannot make judgment whether this is cognizable or non-cognizable. It is completely dependent on the first schedule. Am I clear? So you understood what is bailable and non-bailable, cognizable and non-cognizable. Okay. Next comes a complaint. Okay. What we call as a plaint in Civil Procedure Code is a complaint in Criminal Procedure Code. Okay. Usually, okay, why this chapter becomes easier for all of you is most of these terms are what we have heard or seen in movies, or what we kind of know about. Okay. Why Civil Procedure Code was difficult was because we didn't know anything. Remember the first day, everyone told that, ma'am, terminologies are difficult. That way, you see, even in CRPC, the terminologies are difficult. But because we have exposure to those terminologies more than civil cases, we feel this is easy. Okay. Now, it's very easy for me to relate to what you guys are thinking because you all have heard of it most of the time. Now, what is a complaint as per what you guys know? Don't look at what is there in your institute material. Anything that you guys know about complaint. What is a complaint? With whom is it filed? Anything you guys know about complaint?
It's filed with the police.
Sorry?
It should be in written, ma'am.
Okay, it should
It is
be
given to
written.
the judicial person or authorized person. To the court.
Okay.
Or it can be conveyed orally also.
Okay. Anybody else who knows what is a complaint? Okay.
Complaint
See, the
is
first
anything
thing
which-
is, yes?
Yeah, ma'am, you can continue.
Okay. See, basically, complaint is any allegation that is made orally or in writing to a magistrate. What is important is magistrate here. Okay. A complaint is always made with a magistrate right? We usually associate complaint to a police complaint. Actually, there's nothing called a police complaint at all. Okay, what you file with the police is called as FIR, first information report. Okay, complaint means an allegation that is either made orally or in writing to a magistrate. Why are you filing a complaint? For him to take action under the criminal procedure code that some person has committed some offense. Okay, a known person or an unknown person has committed an offense. Okay, but it does not include a police report. So when we tell complaint, we always associate it with a police report, but complaint is not a police report. Complaint is filed with a magistrate. It can either be in oral or it can be written. Okay, it is against some person who is either known or unknown to have committed any offense. Okay, and it has to be made to a magistrate. It is made with an objective that the magistrate takes some action against that person. Okay, so these are the requisites of a complaint under the criminal procedure code. Am I clear? Now, police report. Yeah.
So when we have any issues, probably with neighbors or anything, or theft, we approach the police station first, and when we speak to the police there, they'll say, "Give us a complaint." They will tell the other person also, "Please take a complaint on this." So, but
what they usually tell is that's what I told. It's actually just called as a complaint, which is more like a colloquial use of complaint. Okay. Legally, complaint means that which is filed with the magistrate. Okay. Then what we file with the police is FIR, that is first information report or a Is that clear?
Yeah.
Okay. Now, in the definition of complaint, if you've noticed, it specifically says that but does not include a police report. Okay, police report is specifically excluded so that it is clear that the report that is filed with the police, okay, is different from what is filed with the magistrate. Police report means a report forwarded by the police to the magistrate. For similar issues, if there is a report forwarded by the police, okay, to the magistrate, that is called as a police report. Am I clear?
Yes, ma'am.
Yes, no, maybe?
Yes, ma'am.
1 second, guys. Clear about what is a police report? What do you say? Complaint, what is an FIR? We'll move on to understand about bail. Okay, I've already explained bail to you, but we'll understand it better. Okay, so bail means release of the accused from the custody of officers of law and entrusting him to a private custody, who are sureties, okay, and who will also be answerable for anything that wrong that goes by when he is in his custody. Okay, in serials and movies we would have seen that, okay, bail pe hum bahar aa jayenge and all of those stories. Okay, but actually it is released from the custody of office of law to a private custody. Okay, under bail we have something called as an anticipatory bail. That is a person who feels that he might be arrested, okay, for committing any offense, right? He has not yet been arrested. He can apply for an anticipatory bail. That is, if I am arrested, I will be in the custody of a private person. That is called as anticipatory bail. Clear? The next comes the term called inquiry. Now I'll just go on term by term. Okay. In case you have doubts, just stop me. I'll clear your doubts. Otherwise, I'll just go on and on. Right. So inquiry means inquiry other than a trial. Inquiry is conducted by magistrate or by the court. Okay. So if any complaint is filed to the magistrate, what the magistrate does is they conduct an inquiry. Okay, so what they do in inquiry, they will find out different things about the case. Okay, now inquiry is a wider term compared to trial. Okay, inquiry is different from trial. Trial of case is different, inquiry is different. Inquiry stops when trial begins. First, they do an entire inquiry and then the trial starts. Okay, so magistrate or court does an inquiry. Inquiry means they will not go find, they will call witnesses, evidences, and everything. After the inquiry phase is over, then the trial actually starts. Okay, so that is nothing but inquiry. Now comes investigation. Basically, investigation is conducted by a police officer. Yes, ma'am.
Ma'am, one second. Trial starts, trial is in the court, right?
Sorry?
Trial. This inquiry covers everything about the case, and trial starts in the court.
Exactly. So, inquiry is wider term. Okay. After all inquiry and all is over, okay, after the inquiry stops, that's when the trial actually begins. Okay, like the hearing and all of those things, actual hearing about the case and all begins after an inquiry is made. When an inquiry is made, they call all evidences, every evidence, witness, everything is gathered. After entire court is satisfied that the inquiry is complete, then the trial starts. In the trial, it's more about listening from the plaintiff and defendant, and then finally passing an order. Okay. Next comes investigation. Okay. When I talk about investigation, investigation is conducted by the police officer. Okay. Or any other officer who is authorized by the magistrate. Okay. It includes all proceedings for collection of evidences. Okay, so it might be as per the order of magistrate or court that the police officer is conducting an investigation. So inquiry is different, investigation is different. Inquiry is done by the court, okay, whereas investigation is done by a police officer or someone who is authorized by the magistrate. Right? So, I mean, to make it more simple, it's here. The first stage is when police officer, either on his own or under the orders of magistrate, investigates into a case. Okay. So, either on his own or as per the orders of magistrate, he investigates the case. Okay. Then he submits the report to the magistrate. Right? Then the magistrate, if necessary, if the police officer says there's no offense at all, then the case stops there. If there is something, if there's a difference in opinion, then the magistrate will begin their trial or an inquiry. Okay. After the entire inquiry is over, then the trial is taken up and the case is completed. Clear?
Yes, ma'am.
Clear or no?
Yes, ma'am.
Yes, ma'am.
Okay. The next terminology is judicial proceeding. Basically, judicial proceeding is the course in which all evidences might be taken, legal oath might be taken, and all of that entire, process of taking up the case, understanding it and everything, and closing the case. Okay. Usually in a judicial proceeding, inquiry is included. Okay, when I say judicial proceeding, inquiry, trial, and close. Okay, but investigation part is not a part of judicial proceeding. Am I clear?
Yes, ma'am.
Yes, ma'am.
Okay. The next comes pleader. Okay, it means a person who is authorized by or under any law for the time being in force to practice in the court, and includes any person appointed with the permission of the court to act in such proceeding. Okay, so pleader is more like a lawyer who is practicing in the court, okay, for any particular case related to that court or related to any proceeding. Okay, then we have a public prosecutor, right? Any lawyer or any officer who is there to assist court, okay, with the fair views or with his views over a particular matter is called as a public prosecutor. He might be an executive officer or an administrative officer, more so to guide the court about his views on a particular matter. Because when I talk about criminal cases, there are cases where you need expert advice, where you need people from executive or administration. Okay, so he is called as a public prosecutor. Am I clear?
Yes, ma'am.
Okay. Yes. Next comes the differences between summons case and warrant case. Okay. Basically, warrant cases are cases relating to an offense punishable either with death, imprisonment for life, or imprisonment for a term which is exceeding 2 years. Matlab, any serious punishments, okay, in going to jail, or jail is a wrong terminology used, being imprisoned for more than 2 years, or being imprisoned for life, or death sentence. Okay, these are called as warrant cases. Anything below that is called as summons case. Okay, so here imprisonment is for less than 2 years in summons case. In warrant case, imprisonment term is more than 2 years. Am I clear?
Yes, ma'am.
Okay. Next, we will discuss about the classes of criminal code, and we will stop at that. Okay, because here only you will start getting confused. So already we have studied civil procedure code. I don't want to confuse you all even more. Okay. The lowest is the executive magistrate. Then you have the judicial magistrate of the second class. Okay. Then you have the judicial magistrate of the first class, or metropolitan magistrate, or in any metropolitan area. Then you have court of sessions, and last you have the high court. Okay. Supreme Court obviously has been vested with the criminal procedure and civil procedure powers. Okay. The Supreme Court also has appellate jurisdiction when it comes to criminal cases, but it does not have original jurisdiction. So which means civil cases, certain case has direct original jurisdiction at Supreme Court, whereas when it comes to criminal cases, only appealable jurisdiction is given to Supreme Court. Appeal against the High Court, you can file in the Supreme Court. Okay. Talking about the powers of the court, the offenses are divided into two categories. Okay, one which is given under Indian Penal Code and under any other law. Okay, so basically for all the offenses under the Criminal Procedure Code, Indian Penal Code mentions about the penalty. Okay, now to talk about what power each court has. Okay, High Court has the power to pass any order. That is, they have the power to pass death sentence. They have the power to pass imprisonment for life or any other imprisonment. Okay, so High Court has the highest power, right? The next comes the Assistant Sessions Judge. Okay, that is Assistant Sessions Court. They have the right to pass any order except imprisonment for life, except death, or except imprisonment for a term more than 10 years. So what does it mean? High Court has any power, but when it comes to Assistant Sessions Judge, their power is restricted to pass an order for imprisonment up to 10 years, not more than that. Clear? Assistant Sessions Judge has the right to pass order for imprisonment up to 10 years, not beyond that. They don't have right to pass death order. They don't have a right to pass imprisonment for lifetime. Okay. Now, what are the sentences which a magistrate can pass? Okay. Now, the court of a chief judicial magistrate can pass any sentence except death, imprisonment for life, or imprisonment for a term exceeding 7 years. See, this is the problem with Indian law. If you see the statement, it says he can pass any order except death, except imprisonment for life, or accept imprisonment for more than 7 years. Instead of all these stories, they could have only told Chief Judicial Magistrate imprisonment up to 7 years. Right? But this is how they word things in law. Okay, that's why it looks complicated. So when I say Chief Judicial Magistrate, he has the power to pass imprisonment. He has the power to pass orders relating to imprisonment for up to 7 years. Okay. Magistrate of first class, up to 3 years. Imprisonment up to 3 years. Magistrate of second class, imprisonment for up to 1 year, and fine not exceeding 5,000 rupees. So fine up to 5,000 and imprisonment up to 1 year. Clear? When I talk about Chief Metropolitan Magistrate, he has the same power of Chief Judicial Magistrate. And when I talk about Metropolitan Magistrate, he has the same power of Magistrate of the first class. Okay, so we have High Court, which can pass any order. Assistant Sessions Judge, who can pass order for imprisonment up to 10 years. Okay, Chief Judicial Magistrate and Chief Metropolitan Magistrate for passing an order for imprisonment up to 7 years. Magistrate of first class, okay, and Metropolitan Magistrate for imprisonment up to 3 years, and a fine not exceeding 10,000 rupees. Magistrate of second class, imprisonment for up to 1 year, and fine not exceeding 5,000 rupees. Is this clear? Understood the logic, or this got confusing?
Understood, ma'am.
Understood, right? So what is easier is just write down each of these magistrate. Below that, one sentence, that is imprisonment not more than 7 years, 3 years, 5 years, whatever it is. Okay, it is more easy than reading it in the book. The minute you read in the book, you will get more confused. Okay, so if possible, just make short notes there itself so that you are not confused. Okay. Now, sentence of imprisonment in default of fine. Now, certain times these criminals are imposed with a fine and they are not levied any imprisonment. Okay, they have told that you pay this much fine and finish your story. But imagine they fail to pay the fine also. First of all, they have done criminal offense. Okay, they are failing to pay the fine also. In such case, what happens? The magistrate has the power to award them imprisonment if they default in payment of fine. Okay, if it is within their power to levy imprisonment. Okay, and for such similar offense, imprisonment is also one of the punishment. Okay, in such case, even if they don't pay fine, they will be penalized by imprisonment. Clear? Now, suppose a person has done several offenses. Okay, the quantum of punishment for that several offenses can be clubbed where there are 2 or more offenses in one trail. In one, the imprisonment is for 3 years, other 1 year. Together, they can club and they can levy a consolidated imprisonment for 4 years. Am I clear?
Yes.
Understood? Okay. Here I will stop this chapter. It is still 10 minutes before the class, but the next topic is so long that it will go on for half an hour to 45 minutes. I know so much patience nobody will have to hear that entire thing. Let us catch up in the next class with fresh mind to understand about offense. Yeah, Chetana, how many of you all read about that CBSE case of Right to Information Act?
Yes, ma'am.
Remember, I had asked you all to read about it. Now nobody remembers also.
Yes, ma'am. Right.
How many of you all have read and how many of you all have not read? Even if you have not read, please be honest.
Read, ma'am.
Okay. Only one person? Okay. So anyone who can summarize the entire case? Anyone who has read it? That's why I asked, be honest. Even if you have not read, it's okay. But I don't want someone to just tell yes without understanding. So how many of you all have read, and who have read, are you in a position to summarize the case?
It's a case about the CBSE and Aditya Bandyopadhyaya, ma'am. It's after
Okay,
scoring
good.
of the marks.
Mm-hmm.
Hello?
Yes, go ahead. Anupama, we can hear you. Okay, other than that, anyone else who has read the case?
Yes, ma'am. Facts of the case. Like, respondent appeared for exams and wasn't satisfied with his marks. So he asked for evaluation of the sheets. But CBSE told that sheets cannot be shown for you. So what that respondent did was went to court under Right to Information Act. With that, he went to court, filed a writ in Calcutta High Court. He allowed a petition. High Court said CBSE should show the answer sheet. But what CBSE did was they challenged High Court judgment and went to Supreme Court. What CBSE said was relationship between CBSE and student was it is a fiduciary relationship which is not covered under RTI. It is written in their bylaws that students cannot ask for evaluation of sheets for checking. What they said was CBSE said this to while appealing. Judgment was answer sheets are information, right? According to Right to Information Act. Then it is fiduciary relationship, but student can ask for answer sheets. It was his right. This RTI overrides their bylaws, CBSE bylaws. So respondent wins in this case, and he will get his answer sheets.
Yes. Okay. Yeah. So this is one part of the case. Good. I think it was Chetana who just answered, right? Okay. Now to elaborate it more. Okay. When this case was filed with the Supreme Court. Okay. Supreme Court also had another order, or rather another part of the order, which was in favor of CBSE itself. Okay. What they said is maintaining these information under RTI is not to divert the business from doing their original business and only looking after RTI. Okay. This has to be purely voluntary, and it should not be an obligation that they forget their business and they do only providing information. People should not take advantage of RTI where they only start questioning the public authorities. That was another judgment, and what she told was another part of the case. Okay, so wherever there is such case studies, please do some reading and come. Last 3 classes we have missed out to discuss about this case. Okay, so thank you, Chetna. While you're writing this case study, again, if you're very sure about the names, mention it. Otherwise, just tell decided in the case law, held in the decided case law. If you are not sure about the name, just don't write some ABCD names. It will give a very wrong impact. Okay.
Yes, ma'am.
All right. With this, with this, we'll wind up today's class. We'll catch up in the next class, and we will do rest of the parts in, rest of the parts of Criminal Procedure Code. Okay. All right, guys. Take care. We'll catch up in the next class.
Bye.